Hello everyone. From my side, my name is Daniele Ape from the ECHA Poison Center, from the ECHA Poison Center team. I'm here today in my presentation to talk to you now about the legal requirement and a bit more in detail about the legal text and what is happening from the legal perspective. So basically, in my presentation, I will try to help you to stay on the top of your obligation, which are changing slightly, and I will help you to understand in which way these are changing. So in my presentation, I will go through the what's happening from a legal perspective with two main changes, two main amendments of this regulation. And then I will highlight, we have highlighted, selected and highlighted for you some specific key points which we think are most relevant for you to keep in mind. And then finally, I will tell you what we are producing to you for you as a support, so support material and guidance that we hope it will allow you to stay up with the up to date and to stay on the top of your obligation. So to start, the First Amendment, the legal text Annex 8 of CLP has been amended already once, and the First Amendment entered into force in January this year, so already since 20th of January 2020. And this was the outcome of 2 years of discussion with stakeholders and authorities, Poison Center, and the Commission. Discussion about specific areas that they were identified and they needed to be further clarified. And this amendment affects not only Annex 8, but also two articles of the CLP regulation, which are the articles dealing with labeling requirements and supplemental labeling information in particular. So the scope of this First Amendment, the main scope is to postpone the first compliance date, as I will explain a bit more in detail soon. But also some other standard requirement and existing requirement have been slightly modified, and then some editorial corrections were made. First of all, as I said, the first compliance date has been postponed. So as you may know by now, the original text of the regulation introduced 3 compliance dates on the basis of the end use of the mixture. Now, if the mixture intended for consumer and professional use, they have now the same compliance date, and this has been moved from 1st of January from 1st of January 2020 to 1st of January 2021. While the last compliance date for mixture intended for industrial use does not change, it remains the same. Another important change or better clarification, which was introduced by this First Amendment, concerns the location of the UFI and the labeling requirement. The amended legal text provides for a bit more flexibility, and in particular, the fact that it is not necessary anymore to include the UFI in the label, as this is a standard situation when the standard requirement can be applied, but you have the possibility in specific cases to place the UFI outside the label as long as it is close to the other label element. So always have to be easy to locate the UFI. It is not necessary then for the UFI to be on all the packaging layer in case your product is packaged in a different layer of packaging. There are also some changes with regard to the identification of the, in particular the mixture in mixture, or MIMs, as we used to call it. The MIM, the mixture in mixture, when it's not fully known, so when you want to identify your mixture in mixture as it is, so have the full composition of this MIM, you can identify it by using the UFI which your supplier has provided to you. This only in case the UFI has been notified in a previous submission by the supplier. So the appointed body, the relevant appointed body, has to have the information linked to this UFI. Otherwise, if you may receive the UFI from a supplier, but this UFI is not known to the appointed body because nobody has submitted the notification, then the meme has to be identified with the SDS composition. So you have to include, you have to indicate in the notification the component that you have from the SDS, and not the SDS itself, like it was used to be. Another important change concerns the pH information, so the pH value, which is a requirement. There are cases where you may not have it for different reasons, and we have been working in order to provide a predefined list of options which you can select, the one which is relevant for you. But the justification when the pH is not available is now mandatory, so it has to be. Now, we provided in our webinar in February a bit more information in detail about the First Amendment, so I suggest you to go back and to have a look at the slides which are available on our website, in case you want more information about the First. I switch now to the Second Amendment. The regulation will change again, and I would like to underline the fact that all these changes in the legal text and therefore also system are meant to facilitate, to solve issues. So they should not be seen as additional burden for industry. In particular, the Second Amendment is a workability amendment, meaning that certain workability issues were raised by industry and were analyzed and identified by the Commission and the authorities. And the purpose is to provide solutions for these main issues, but also to, at the same time, to seek a balance between the need to provide information which are relevant, which is the purpose reason, but also the administrative burden for the submittals. It's something that should be, the requirement should be implementable, applicable. And the Second Amendment, the draft Second Amendment is ready and is undergoing the final step of the legislative. I will go through these main issues and the solution which are included in the draft amended legal text. There are three mainly. We have one issue which is more cross-sector, so it applies to different sectors potentially, and is about the fact that you may have you may have to notify a mixture which has a high composition variability. This because some of the components may be, for instance, purchased by from different suppliers, but they are virtually similar, the same, and you don't know exactly at each point in time exactly which of these components is present in your final mixture. So the solution proposed is the possibility to so-called interchangeable components, so components which are similar enough from a toxicological, chemical point of view. They have the same function, but they can be grouped in the same interchangeable component group. Basically, you indicate this group, you indicate which components are part of this group, but you don't need to indicate the exact concentration of each single interchangeable, but only the information we provided that interchangeable component. This, of course, is possible if the classification of the final mixture does not change, regardless of the specific interchangeable component present at each time. Then the first of the two issues, which are more sector-specific, is the following: the fact that certain industry association, they claim and they inform that the mixture actually they need to fulfill specific standard defined by properties rather than the composition. So they may have a high variability of unknown components, maybe raw materials, which are combined in continuous production processes. So for this mixture, it will be very difficult or cumbersome to comply with the regulation, which will require many notification, many updates, and many generation of UFIs. So the solution which has been found is to include in the legal text specific list of standard formulas, and these were standard formulas suggested by these four industry associations, these sectors: so cement, gypsum, concrete, and fuels. So mixture with composition corresponding to this one of these specific standard formulas can be notified, will be possible to notify according to this formula. So basically, it will be possible to deviate from the default Annex 8 requirement. And this is a closed list of standard formula which have been presented, discussed, and approved. The second issue that it's more sector specific, even more sector specific, concern the point of sale paints. Basically, we have formulation which are mixture which are formulated on demand at the point of sale, and the legal text will introduce and define the term bespoke paints. So this, of course, would require a high number of notification and the generation of many UFIs by the retailer, by the person in the shop formulating this paint. In the draft amendment legal text, the exemption is introduced, is proposed. Basically, there will be no need to notify the bespoke paints as long as on the label of this product, the UFIs of the hazardous components are indicated. Now, which are the timelines for this second amendment, since I can understand this is an important issue because the first compliance date is approaching. So the Commission has worked hard on this draft. All the stakeholders and authorities, Poison Center, have been consulted and a comment taken into consideration. And the draft text underwent final consultation with the competent authorities in May, the 15th of May. Actually. Then the normal legislative process foresees some steps before the Commission can finally adopt the amended legal text, and this is expected to happen sometimes by the end of the summer. So the legal text, the new requirements will enter into force following the scrutiny period, likely right after the summer. Now, as I said, we have selected and we want to present to you a few points that we think are most relevant for you to consider. The first one, and this is very important from a practical point of view in the preparation of your dossier and your submission, is the management of the legal entity. So the legal entity details are mandatory, and they're mandatory at mixture level. So the legal entity has to be assigned to the mixture, and has to be, and then you have a legal entity also in the submission portal. And the consistency of these two is important to avoid validation failure. And both these legal entities, both in the final mixture and in the portal, they represent the duty holder, basically, the person who has the obligation to submit this information. So before you submit, you're recommended to check these two the information about the legal entity in these two places, and this must be the same. This is a potential issue for possibly those companies or those parties, third party, which are preparing and submitting a notification on behalf of the duty holder, or possibly also for users of Euclid standalone, which they may have to do something in order to ensure the consistency of the legal entity identifier in the local installation and in the ECHA account. It is very much relevant in these cases, the concept of foreign users, which is explained in additional support material, and this is the possibility for a duty holder to assign this role to a third party and allow this party to work on their behalf and to guarantee the consistency of the legal entity information. We have just published in May a Poison Center Notification Practical Guide, which provide instruction, useful information, and then also the ECHA account manual, which have been available for a long time, provide an insight and help on this. The second point we want to clarify again, and we will never stop clarifying, is the definition of the duty holder and the role of the different operators in the supply chain. So Article 45 defines specific duty holders. So there are operators which fulfill the definition of downstream users and importers. And here we have to refer to the definition which have been implemented and used under REACH and CLP since the beginning. So the duty holders under Article 45 are those companies using the mixture in rich and CLP terms, so such as formulator, toll formulator, refiller, and repackagers. Those are the operator with direct notification labeling obligation according to Annex 8. But we know that the supply chain is a bit more complicated than that, and there are other operators that they may, for instance, only distribute, so purchase and further distribute the product without using it in terms of downstream use. And these are, for example, retailer, relabeler, rebrander. But all the operator along the supply chain, they have one common obligation, which is to place on the market mixture which are CLP compliant. So the responsibility to comply with CLP with regard to a specific mixture is eventually shared. And it's very much important to work together in the communication, but the communication between supplier and downstream users and customers and distributors is a two-way communication. In fact, the distributors, they play an essential role in this situation when we are trying to avoid information gaps, information which is actually relevant for the poison center. So when the distributors, for example, changes the trade name of a product, which is a very important identifier used by poison center, the appointed body, or when the distributors places the same mixture on a market, a different market than the one where the supplier has submitted the information, then you see that there may be an important information gap which needs to be fulfilled, which can be filled. And this can be done by either informing the supplier who will include this information in notification, but alternatively, the notification can be made by the distributor itself, even if it doesn't have direct obligation under Article 45. So the option are two. Finally, another important point that we want to highlight is the fact that the notification should be submitted in the official language of the member state, even if some of the member states allow the use of the English. Sorry, even if the English is not the official language. If you submit a multi-country notification, the information has to be in all the languages. And the market areas and languages needs to be set when you prepare your dossier, in the dossier header. And then the system will automatically provide you the free text field, which needs to be manually filled in all the different languages, like, for example, toxicological information or certain field required in the classification and labeling section, for instance, in some other statements. Now, the multilingual notification are supported they were not supported in the older version of Euclid offline. So that's why we always advise to upgrade and update to the latest version, while in the Euclid Cloud Online, this was already supported. Now, I would like to conclude my my presentation, talking about support and guidance. So you have heard a lot of things, a lot of requirement provision are changing, and we are trying to help you as much as possible to stay on the top of these changes. So in May, we have finalized and published the update of the guidance of Annex 8, but not only that, also the guidance on labeling and packaging in accordance to CLP includes now important changes. And these two documents, they reflect the regulation, the legal requirements like they are now, including the First Amendment. There are other guidance documents that may be relevant for you, like, for example, the substance in article guidance or the safety data sheet guidance, which they include relevant information in this case. Now, not only guidance, we have a wide array of support tools and documents published on our website. We have some targeted tools like guides or manuals or key documents and leaflet addressing specific topic, and then some example, and then some publication like the Q&As which we try to keep up to date as much as possible, and some e-learning materials like videos, for example. And then on the Poison Center website, there is always this section which presents you the steps that the industry should follow one by one in order to get ready and fulfill the obligation. Finally, we advise also, we recommend you also to stay connected with us via LinkedIn. Our LinkedIn page contains a lot of information. We keep up to date, and there are regular relevant posts, and we are in contact with our growing community. So please join our group if you can. This is all from my side. Thank you very much for the attention, and and I advise you to keep following also all the other presentation in order to be completely up to date with everything that is happening with regard to the Poison Center notification. So thank you very much.